Benami Transaction Act, 1988. Ostensible owner, owner property not owner. A person may have possession and enjoyment of the property, and may also have his name entered in the official records, but even then he may not be the real owner of that property. When a person purchases property in the name of another person, it is called a Benami transaction. A benamidar is an ostensible owner. Where some property was purchased by a father in the name of his minor sons. A person does not become ostensible owner if the real owner has entrusted him with temporary control over the property only for some specific purpose, or where he holds a property as a professed agent or as guardian of minors' property or in any other capacity of fiduciary character. In Giridra Nath Mukherjee vs. Soumen Mukherjee AIR -1988 call.375, the person in whose name the property is purchased is called benamidar. A benamidar is an ostensible owner. Where some property was purchased by a father in the name of his minor sons, the Calcutta High Court held that sons were ostensible owners because minor sons had no means to acquire property, and they were not intended by the father to be real owners of property. Transfer by ostensible owner. Section 41 provides that where an immovable property is transferred by an ostensible owner with express or implied consent of the real owner. Ostensible owner is not a real owner of the property. He has no authority to make a transfer. Section 115 of the Indian Evidence Act provides that where a person by his declaration or act permits another person to believe a thing to be true and to act upon such belief, he shall not be allowed later on to deny the truth of that thing. Essential conditions for Section 41. I. There is transfer of an immovable property by ostensible owner with express or implied consent of the real owner. 2. The transfer is for consideration. 3. The transferee has acted in good faith, and 4. The transferee has exercised reasonable care in finding out the transfer power to make the transfer. 1. Express or implied consent of real owner. The transfer of property must be made by an ostensible express owner with express or implied consent of the real owner. However, whether the consent be expressed or implied, it must be a free consent where a benamidar obtains the consent of the real owner by fraud, force, coercion. The consent is not free and this section cannot apply. The consent of the real owner is expressed if it is given in clear words authorizing him to make the transfer. The consent is implied if the real owner knows that the benamidar is dealing with his property as if it were his own but remains silent or acquiesces. Ramkumar Kundu vs. McQueen. In this case, one Alexander had purchased some landed properties in Calcutta in the name of Bannu Bibi, who was his mistress. McQueen was one of the 2 children born to him by this mistress. The sale deed was in the name of Bannu B, and she also used to manage the properties. Later on during the life of Alexander, Bannu B sold the properties to Ramdhone, father of Ramkumar. After the death of Bannu B, McQueen filed a suit against Ramdhone claiming the properties on the ground that her father Alexander had left in Jensen her favor, and that her father was the real owner, not Bannu Bibi, who was merely a benamidar. Ramdhone pleaded that he was a bona fide purchaser without notice of the benami title of the seller. Finally held that even assuming that Alexander was the real owner and that Bannu Bibi was merely an apparent owner, since Alexander had allowed Bannu Bibi to hold herself out as the real owner, he or his representatives could not recover upon their secret title unless they can prove that purchaser had direct or constructive notice of the real title. 2. Transfer is with consideration. Section 41 is applicable only where transfer by an ostensible owner is with consideration. It does not apply to gifts or gratuitous transfers. 3. Transferee acts in good faith. It is necessary that the transferee acts in good faith, i.e., he has purchased the property in the honest belief that transferor had power to transfer the property. Good faith means bona fide intention. Where a person purchases property with full knowledge that the transferor is merely an apparent owner, his intention is not bona fide and there is no good faith on his part. Even if the purchaser makes due inquiry about the title of the seller, but has no good faith, therefore purchases the property with dishonest intention, he cannot get the benefit of this section. In Guru Baksha Singh v.S. Nikta Singh, AIR 1963 S.C. 1917, there was a partition of joint family property, but there was also some dispute over the respective shares. While the objection and application for the correction of mistakes was still pending, a part of the property was sold. The Supreme Court held that since parties lived in the same village, and the facts established beyond reasonable doubt that the purchaser had knowledge of the disputed title of the seller, the purchaser had no good faith. The court observed that in the absence of good faith on his part, the purchaser cannot claim the benefit of Section 41. 4. Reasonable care of the transferee. The transferee must also have exercised reasonable care in ascertaining the title and authority of the transfer. Reasonable care means that care which a man of ordinary prudence should take while making inquiries regarding the title of an immovable property. Nageshwar Prasad, V.S. Rajapateshri in this case, in the revenue records, instead of A the name of B was entered by mistake. B mortgaged the property to C, who accepted the mortgage relying on the revenue register. A denied the transfer on the ground that B was not authorized to mortgage the property. C claimed the benefit of this section on the ground that he had taken reasonable care in ascertaining the title of B by inspecting the revenue records. The Privy Council held that since C had not exercised reasonable care in inquiring about the authority of B, he cannot get the benefit of this section. Finally, the court held that if C had made further inquiries, he would have found that B's name was entered in the register by mistake and had already raised an objection against the wrong entry of B's name in the register. 5. Subsequent transfers. The first transferee and every subsequent transferee is entitled to the protection. The subsequent transferee must be a transferee for value, without notice of the real owner's title and having made reasonable enquiry of the transferor's power of disposition. If all conditions are satisfied, such transferee shall not be deprived of the protection, even if the first or any intermediate transferee had notice of the title of the true owner. Transfer by a co-owner. Where a property is jointly owned by two or more persons, it is a co-owned property. Every co-owner is entitled to common enjoyment of property. Sec. 441 enacts that where a co-owner transfers his share, the transferee is substituted in the property to the extent of the share transferred to him. The transferee too is entitled to common enjoyment of the joint property together with other co-owners. It will acquire all the rights and liabilities which the co-owner had in the joint property at the date of the transfer. Just as the co-owner was entitled to partition, the transferee shall be bound by the conditions and liabilities affecting the share transferred to him with effect from the date of transfer. X, A, B, and C co-owners of a piece of land having equal shares. The land is subject to mortgage. C sells his one-third share to D without effecting partition. Under this section, D would be substituted in place of C for all rights and liabilities. D is therefore entitled to common enjoyment of the land as C was before the transfer. D has also the right to one-third share partition from other co-owners and have separate possession of his part of land. But The one-third share which D has purchased shall still remain subject to mortgage. Dwelling house, it means not only a residential structure or building, but the expression includes also the adjacent buildings, gardens, courtyard, orchard, and all that is necessary of the convenient use of the house. Where the co-owned property is a joint family house, in co-owner has right to transfer his share, but the transferee is not entitled to be substituted in his place. Where the transferee gets a share in a residential house owned by family members of joint family, he is not entitled to have common enjoyment or possession of the property. Where a share in a dwelling house is transferred without partition, and the transferee too does not maintain suit for partition but attempts to take possession of his share, the other co-owners may restrain him from taking possession. Joint transfers, Sec. 45 of the Act TPA deals with apportionment of distribution of interest in property transferred to two or more persons. When property is transferred to several transferees jointly, then there might be two situations. 1. The consideration amount may be a common fund. 2. The consideration may be advanced separately by each transferee. Where consideration is paid by the transferees from a common fund, the interest of each transferee in the property shall be identical with their interest in the common fund. But, where the consideration is paid by each transferee from their separate funds, the transferees take interest in the property in proportion of their respective share in the whole consideration amount. Where a property is purchased out of common fund in the name of any one of the contributors with consent of the others, then the person in whose name property is purchased does not become the owner of that property. In the absence of any evidence to show the respective interest of the transferee in the common fund, or the shares which they have advanced, the transferees shall be presumed to have equal interests in the property. Rajeshwari v.S. Balchand Jain. In this case, in a joint Hindu family, all the members were residing in a house and carrying on joint business of the family. No partition had taken place. A plot of land was purchased, and the source of money appeared to be joint earnings. The court held that there is no presumption that every property purchased by the members of joint Hindu family is property of joint family. Apportionment by time. Apportionment means distribution of a common fund between two or more claimants. Section 36 of TPA provides that in a transfer of property, all rents, annuities, dividends, and other periodical payments in the nature of income shall be deemed to accrue from day to day and be apportionable accordingly. The periodical income, which the property shall be distributed between transferor and transferee at fixed date on the basis of its accrual on each date. For instance, A's house is on rent of Rs. 300 payable at the end of each month. A sells this house to B on 15th April. Thus B became owner of the house with effect from 15th April. A, the seller, is entitled to get Rs. 140 as rent for 14 days, and B, the purchaser, shall get Rs. 160 as rent for 16 days out of Rs. 300, which is rent for the whole month. Apportionment of benefit of obligation to several persons. Property is divided and held in several shares, and thereupon the benefit of any obligation relating to the property as a whole passes from one to several owners of the property. The severance does not substantially increase the burden of the obligation, but if the duty cannot be served. Illustration: a sells to B, C and D a house situated in a village and leased to E at an annual rent of Rs. 30 and delivery of one fat sheep. B having provided half the purchase money, and C and D 1/4 each. E having notice of this, must pay ₹15 to B, Rs. 7.50 to C, and Rs. 7.50 to D, and must deliver the sheep according to the joint direction of B, C, and D. Apportionment by estate. Section 36 incorporates apportionment by time and apportionment by estate where an estate is transferred in such a manner that after the transfer, it is to be divided in several shares. Then, the obligation of the benefit of property must be performed in favor of each sharer in proportion to the value of each shares. Conditions. 1. The person under obligation to pay the benefit in proportion to respective shares must have reasonable notice of the fact that on transfer the estate was divided into several specific shares. 2. The obligation must be capable of being performed in parts in favor of each owner. The 3. Property is capable of being severed or separated. The severance must not substantially increase the burden of obligation. Expectations. A. Transfer by operation of law, transfer by operation of law or involuntary transfer e.g. succession, are exempted from this rule. B. Agricultural tenancies. The rule is not applicable to agricultural tenancies because on transfer, the division of obligation to pay to several owners may cause much inconvenience and harassment to agriculturists. Priority. Sec. 48 of the T.P. Act says that owner of an immovable property is at liberty to transfer any kind of interest in his property to any person. He may transfer partial interest to one person and absolute interest to one person, and absolute interest of the same property to another person. X. An owner give his house on lease to A and mortgage the same house to B and ultimately sell it to C. Whenever such successive transfers are made, the ultimate transferee takes the property subject to prior interests. Essential elements of priority. 1. A person purports to create rights in or over the same immovable property. 2. At different times. 3. The subsequent transfers are such the rights in property cannot be exercised to their full together. Different dates to transfers are made successively on different dates or, if made on the same date, one is earlier to the other. Where the transfers are made through registered instruments, it is the date of execution and not the date of registration which determines the precedence. Exceptions to the rule of priority. Sec. 48 of the will not applicable to the following cases. 1. That the instrument if transfer is executed by fraud, misrepresentation or in gross negligence, etc. 2. In a suit for partition, if a receiver, under the order of the court, mortgages whole or part of the estate, the mortgagee would be entitled to priority over an execution creditor by whom the property was attached after the commencement of the suit for partition. 3. In lieu of a co-sharer for royalty money on partition, though subsequent in time, is given priority over earlier mortgagees of property allotted to the co-sharer, who is liable to pay royalty. Improvements. Sec. 50 rent bona fide paid to holder under defective title. No person shall be chargeable with any rents or profits of any immovable property which he has in good faith paid or delivered to any person of whom he in good faith held such property, notwithstanding it may afterwards appear that the person to whom such payment or delivery was made had no right to receive such rents or profits. Illustration. A lets a field to B at a rent of Rs. 590 and then transfers the field to C. B having no notice of the transfer, in good faith pays the rent to A. B is not chargeable with the rent so paid. C. 51 of the Act provides that one who seeks equity must do equity. This section gives relief to a transfer who makes improvements in good faith on the land held by him and is being evicted subsequently by a person having better title. The person claiming eviction of a bona fide purchaser, who made improvements, must be estopped. from refusing to pay the compensation because his own acquiescence was responsible for those improvements. Provisions of Section 51 provides that 1. When the transferee of immovable property 2. Makes any improvement on the property 3. Believing in good faith that he is absolutely entitled thereto, and 4. He is subsequently evicted therefrom any person having better title, then the transferee has right to require the person causing eviction to either give the value of improvement or to sell his interest in the property. Essential conditions of Section 51 is clear from the analysis of provisions of this section. Following conditions are necessary for the applicability of this section. A. The person who is being evicted is a transferee, and B. Such transferee had made improvements believing in good faith that he was absolutely entitled to do so. Transferee of immovable property. The equity enacted in this section gives relief to the transferee of an immovable property who believes himself to be absolutely entitled to make improvements. The scope of this section is limited in the sense that it applies only to transfers or absolute interests, e.g., sale, gift, or exchange. In the following cases, the transferee has been given the benefit of this section. 1. Where the transferee who purchased a property was given possession of a larger area than he was entitled under the deed, and who made improvements on excess land under a mistaken belief that he was entitled to do so. Natesa Tevin vs. Dist Board of Tanjore, AIR 19-60 Mad 921. 2. Where the transferee had purchased an immovable property exceeding Rs 100 under an oral agreement, Tapanmal vs. Chatalmal, 1940 Kar.41. 3. Where the transferee has purchased a life estate believing that the vendor was absolutely entailed to sell the property, Nanjamma vs. Nacharammal, 1,90,717 Mad. LJ.622. 4. Where the transferee purchased the property bona fide in ignorance of mortgage, Narayana Rao vs. Basraappa, AIR 1956 SC 727. Where the transferee had purchased a minor's property bona fide in ignorance of mortgage. Horilal vs. Gordhan, AIR 1927, Bomb.611. 6. Where the transferee was a grantee from a tehsildar, but believing that he was absolutely entitled to do so had planted certain trees on the land, Chennapragada vs. Secretary of State, AIR 1925, Mad 9